This is a lecture on Lesson Module 6, Criminal Procedure. These are the objectives that I hope you'll be able to accomplish after completing all the assignments in the module. And we're going to start out with a discussion of just the very basic concepts. Um, First of all, what are we talking about when we say criminal procedure? And I mentioned in the last module that there is a body of law called criminal law that defines what crimes are in our society and then sets forth the punishments for them. Now we're talking about the procedures for how crimes are prosecuted. And that's what criminal procedure is. It's its own sort of body of law that relates to the procedure of criminal prosecutions. So we're talking about steps and the rules that guide prosecutors along the way as they go about prosecuting a defendant, and then the rules that provide for the constitutional limitations on that process, and then the laws that provide defenses for criminal defendants to push back against the prosecution and avoid liability. So this is its own sort of little body of law. But we'll get to the more details about the sources of those laws and how they're provided in just a minute. But I just wanted to start with that basic idea of what are we talking about with criminal procedure. Um, if you remember in lesson module 4, you all had to create sort of a timeline of criminal process with the various steps and stages and understand what they were. And that's a good thing to do right now is to review that, because the rules that we're learning now fit into each of those steps and stages. They're a part of those steps and stages. So you'll see how for example, the due process requirement of providing notice of the charges against you. Well, you would see that at the arraignment. You would see that in the complaint. You would see that at the bail hearing. I mean, they're all different parts or steps in criminal process where that due process rule is provided. So due process, let's talk about that. We studied in one of the prior modules also what we mean by due process. I think that was explained actually in a video. Due process means fair law. So we're talking about a rule that governs our country. Government cannot take away our life, liberty, or property except according to law, fair law. So these are the rules that make things fair, or seek to make the system fair, so that if someone does lose their freedom, it's because it's justified. It's just in our system to deprive them of their freedom as punishment for a crime. Now, step back a minute. What is the purpose of criminal procedure? Well, it's to accomplish that due process, to accomplish the protections that our Constitution provides for individual freedom. Um, and it's to uphold the integrity of the criminal justice system, to make it just, to make it fair. And well, you'll understand a little more. We'll look on to the next slide, what we're talking about. If you remember, we studied about two models of the criminal justice system. Herbert Packer provided them, and they're ideal types. There's the due process model, and there's a crime control model. And I'm going to go over them again, even though you should already understand them. But I want you to see how criminal procedure works to incorporate some aspects of both models. If you remember the due process model, the chief concern is the protection of individual rights and freedom. Individuals are presumed innocent, and the government has to jump certain hurdles or go through certain obstacles, or go past certain obstacles before they can take away a person's freedom. And that is part of the due process model, upholding the integrity of the system. We live in a country where we say individuals have rights. Government power is limited. Well, that's not going to mean anything if there aren't detailed rules that actually enforce that principle. And so the due process model emphasizes that um, uh, it emphasizes that purpose of wanting to make our system have integrity and to actually give due process to the citizens of our country. The crime control model, the chief concern is the protection of people, public safety or community safety, providing order. Um, and in that model, your criminal justice system is afforded a good bit of faith. We we provide greater discretion to police and prosecutors, trusting them to get it right. So in that model, you would not have a lot of obstacles. We would allow criminal justice or criminal process to go very streamlined, and assume that the police have arrested someone because they know that person's guilty. The person being prosecuted who is found guilty is most likely factually guilty. Um, and so it's sort of the flip side of the due process model. So due process is, we're not as trusting, we're limiting government power. And then on the crime control side, we're giving greater discretion to the government and trusting them to get it right. But there's risk involved in both models. So under the due process model, the risk is that a factually guilty person's going to go free, because if there's a violation of some due process right, well, there's a remedy for that violation, and it will mean that certain pieces of evidence will not be given to the jury, or a case may have to be dismissed. And that means a factually guilty person may go free. There's a risk of that. But under the due process model, it's worth it. It's worth that risk to uphold the protection of individual freedoms and the integrity of our justice system. We're willing to risk that. The crime control model, the risk is that innocent people will lose their freedom and have little recourse, because in that model, we would rather have a safe community, a safe society, and just run the risk that sometimes we might get it wrong. It's very unlikely, but it's worth that risk in order to uphold safety, to maintain the safety. So now these are two sort of extremes, right? They exist on you can look at it as like the line you see at the bottom of the screen, like a spectrum. You could see it as a pendulum swinging back and forth, or the scales of justice, whatever works for you. I want you to recognize that the extent that we go towards upholding due process takes away or risk the loss of crime control. And then the more we give to crime control, the more we're going to take away from due process protections. So it's called a zero-sum game. You can't have it both ways, because the more that you move towards the crime control side of things, the more you're taking away from due process protections. And the more you move towards due process protections, you're taking away from government discretion and crime control. So our justice system then cannot exist on either end poles. They can't get to the extremes. That wouldn't work. We have to be in the middle. And so as we study the due process laws, you're going to see that it is all about striking a balance or a happy medium between these two models. So some of the laws that you'll see are all about giving due process protections to individuals. And then some of the laws you're going to see are about protection, giving discretion to prosecutors and police, letting them rely on their judgment and experience in order to provide public safety. And so there'll be rules, and then there'll be exceptions. There'll be remedies for violation. it's all of the laws are about striking a balance, trying to find the sweet spot in the middle where all of the purposes of criminal due process are provided. We do have safety, we do have due process, and they exist in tension with one another. But we're doing as best we can to accomplish all those purposes and to have a system with integrity, but also have a safe society. And it kind of swings back and forth over the course of time. You may notice that laws change as our concerns for due process or our concerns for crime control shifts. There are times in history where we've been more concerned about public safety than we were about due process. For example, right after 9/11, the Congress passed the Patriot Act that gave a lot of discretion to federal national security institutions and placed at risk the due process protections of individuals, their privacy. And so we sacrificed that, or the public was willing to sacrifice that because at that point in history, we were more concerned about our safety. But then in the civil rights movement, where the public was becoming more aware of abuse of power and the exploitation and terrible treatment of African Americans was being recognized as an evil. So we gave we placed greater concern with due process, and laws were passed to ensure that all people, regardless of race, received the same protections. So you'll see during history kind of sometimes a swinging of that pendulum. Where does criminal due process law come from? Like, I'm not talking about like natural law theory or positive law theory. I'm not talking about that now. I'm actually like the books and the documents. Where do you find criminal due process law? Well, you're going to start the U.S. Constitution because obviously that is where due process principles are entrenched. They are the limitations on government power that protect our individual freedoms. So you think of the few provisions in the original Constitution. There are some that afford due process protections that we've covered in prior modules. And then primarily, though, it's the Bill of Rights, the 4th, 5th, 6th, and 8th Amendments. And that's what this module is mostly about, is about the interpretation and application of those 4 amendments. State constitutions also provide due process law, criminal due process law. They're very similar to the U.S. Constitution, but states can give greater protections for due process. They just can't provide less protection for individual rights. They can provide more, but not less, because U.S. Constitution is the supreme law of the land. It sets the standard for what due process rights people have. States can give greater protection, but they can't give less protection. If they did, they would violate the U.S. Constitution. Legislation goes a long way towards providing the more detailed laws that govern criminal due process. And they usually take the form of the book of or the rules of criminal procedure that are, I mean, it's in its own little book that lawyers learn or students learn in law school. You learn criminal procedure. They're very detailed rules, deadlines about what's going to happen when. So in those steps and stages of criminal process, the details of those stages and steps, the deadlines, and what what each stage really is comprised of is set forth in these rules of criminal procedure. But then there's also statutes and codes that provide other protections, more of it like an elaboration of what's in the Constitution. And we talked about constitutional law, the cases interpreting the U.S. Constitution. They are also a source of due process law and will explain where, where prosecution has gone too far, where a statute runs afoul of the Constitution, they're applying judicial review to the rules of criminal procedure to make sure that the Constitution remains upheld. So each of the topics that are in this learning module, the topics that are part of the Fourth, Fifth, Sixth, and Eighth Amendments to the Constitution, for each one of them, you start with the amendment, like the Fourth Amendment, for example, search and seizure. You start there, and you want to learn what the Constitution says. What does the Fourth Amendment say about search and seizure? And then you're going to want to look at the constitutional cases that interpret that language and kind of flesh it out, elaborate upon it, and explain the more detailed rules that come from that initial language of the Fourth Amendment. So and that was just an example. Each of the topics in this learning module work that way. That you start with the Constitution and then you look at how the cases have interpreted that language from the Constitution. And so your main assignment for this learning module is to take one of those topics that you find in chapter 6 of your textbook and to create a presentation about it. You starting out with what the Constitution says, and then what are the rules that a U.S. Supreme Court case has provided as an elaboration of the Constitution. So you need to go back in Blackboard and look at that assignment, see the detailed instructions about exactly what you're supposed to do. But generally, this is you creating your own PowerPoint presentation on a topic that's part of this module. And I've pretty much, with this assignment, once all of you have created your presentation and submitted it and it's on Blackboard, we'll have a presentation for each of the topics in the chapter, or most of them. So I don't have that, and it's not part of my lecture. I'm not going to lecture on all of those specific topics from that chapter. I'm going to let each student, depending on what your last name is assigned a topic, and then you all will create that presentation that I would otherwise have provided. But this is a way for you to teach each other the material. So you've got a lot of responsibility for learning your topic and then presenting it in a clear fashion through a PowerPoint. At the end of the week, at the end of this lesson module, I will share an outline of the information covering all of it in chapter 3, but I'm not going to do a PowerPoint on it. I'm not going to do a lecture on it because I want you guys to take that on for yourself. You'll learn by teaching it. So you've got to learn it and then be able to teach it. And that's deep learning. When you do that, I think you'll find this a very helpful assignment. And I'm always here to answer questions if you have any trouble figuring out what the book means or what your assigned Supreme Court case is, how to interpret it. I'm happy to help you along the way. Please don't hesitate to email me. I'm very quick about responding. I'll do everything I can. I can meet with you if you'd like me to go over things as well. But that's it for this lecture, and I look forward to seeing your presentations.